Welcome everyone. We are hosting a webinar on amending governing documents, practical pointers and provisions, talking about a variety of things today, but specifically how to amend your governing documents, the process to do it. We'll be talking about MARTA, and at the end we're going to be talking about maybe some specific ideas and concepts to consider amending as we get into the summer months. That's a very popular kind of project to undertake, especially in light of what we have learned so far in 2020. We wish we had in our governing documents. Maybe it would have been better if we had something more specific. So we will start with Mr. Peterson, Scott Peterson, introducing himself, give an overview of how the amendments will work, how to amend your governing documents, and things to look out for when you're trying to get the support of the owners. Then Stephen Thompson will introduce himself, and he is going to talk about some more specific issues, starting I think with MARTA and some other general concepts, and we'll end with myself talking about some of the nitty-gritty items that you might want to look at with respect to amending your governing documents. We are set for 90 minutes. We were thinking we would each speak for 15 or 20 minutes, but we're okay with taking some comments and questions in between, and then trying to leave about 15 minutes at the end for questions as well. So with that, Scott, if you'll introduce yourself and get us started.
Thanks a lot, Telese. I'm Scott Peterson. I have my own firm. The law office is Scott K. Peterson, oddly enough named. And I practice in this area. I advise condo and HOA client boards on their day-to-day matters. I also do quite a bit of litigation matters involving condos and HOAs. When we're talking about amending governing documents, it's a popular question, and the big issue I think that most boards have to address is, why do we want to do this? Telese and Stephen will address, I think, that part of the presentation more than I will. But you always want to determine, I think, because why you want to amend your governing documents will in large part determine how you go about this. And I'm sorry if I say things here that are a little basic and elementary for some of you who are pretty well educated on this, but I do want to give us some basics to understand what we're talking about. One of the things to keep in mind is there's a hierarchy of governing documents. And in Florida condos and HOAs, the declaration is the constitution, the governing document that controls over all the others. All the others are ranked below that. So if there's anything inconsistent with the other documents, inconsistent with the declaration, you got to keep in mind that the declaration controls. That's a point that we're going to come back to again and again and again. After the declaration, we've got the Articles of Incorporation. Articles of Incorporation are more like your corporate charter that detail the powers of the corporation. Then there's the bylaws below that. The bylaws can talk about the procedures for holding elections, that elect your directors, how to run board meetings, that sort of thing. And then below that is the rules and regulations, which are generally speaking board-made rules that kind of flesh out some of the specifics for items in the declaration. For example, if you want to change your pool hours, rather than amending your declaration, you probably want to put those in the rules and regulations, because as we'll talk about, the rules and regulations are very easy for the board to amend in most cases. The declaration is always somewhat harder. So some items that are more ministerial and administrative, the pool hours, when is the fitness center open, any sort of parking regulations, that sort of thing. Generally speaking, those are in the rules and regs. When you're talking about what you want to do in terms of amending the documents, the first question is, are you considering something a very narrow area? For example, I think Stephen will talk about leasing regulations and rental regulations. Is it only that part that you want to amend, or is it everything? I mean, has it been 30 years since your documents have been amended and you want to do a full scale, like let's rewrite the whole thing, let's bring it all up to date? Or is this a very narrow area? Because that may dictate the way in which you go. A lot of boards, and we'll talk about this in a little more depth, but the reason why this becomes a problem is it's usually very hard to amend the declaration. for whatever reason, when the developer issues the initial governing documents, they tend to make it very difficult to amend the declaration. And the reason why is, for example, the statutes, 718, I think it's 111, and in HOAs it's 72306, I believe, set forth if their documents don't state a threshold for amendment, you have to get 2/3 of all owners to vote in favor of the amendment. Well, that's a very high threshold. Just think about your day-to-day life. Politics, for example. Can you get 2/3 of anybody to agree to anything? So you see, just from the outset, it's very difficult to get to that threshold. Why do they make it so difficult? Well, part of the reason why is you don't want to kind of willy-nilly amend the declaration on a whim. It should be a little difficult to get there, but maybe not quite so difficult. So one of the things we always talk about with the boards is look at your amending procedures and look at the threshold required. Like I said, 2/3 is hard to get to. A lot of documents say 75%, very hard to get to. You could have as high as 80%. If you do have a high threshold and you suspect that it's going to be difficult to amend the governing documents, the first thing you probably want to talk about is changing that amendment provision itself. Before you embark on, let's rewrite the entire scope of the governing documents and put a lot of work into that effort, which can take a long time and cost a lot of money, maybe we should see if we could make it easier to pass those amended documents once we get to that point. Amending the amendment procedures in your declaration isn't a very complex operation. And the first thing you think about in amending that amendment provision is to say, right now, in most documents, I think when you review them, people who don't vote for the amendment one way or another, people just throw away the ballot or the proxy and they don't participate, those folks are counted as no votes. So those folks who don't participate are counted against you. That's why it becomes so difficult. It's hard to get people to participate. Well, I think common sense would tell you that that's not a great way to look at things. I mean, we should consider those people who participate, those people who are interested, those people who want to attend, and consider their participation rather than people who can't be bothered with it. So one of the first things we do is we amend that amendment provision to say, okay, we don't want to take 2/3 of everybody. We want to take 2/3 of those who are present at the meeting, either in person or by proxy, and participating in the vote. So if you're participating in the vote and we get as long as quorum is obtained, quorum is about usually 30% of the folks who live in the community. As long as you got 30% participating, your amendment procedure should consider, one of the things to consider is to just take 2/3 of those folks who are going to participate in the election. That seems fair. Moving on from that, however, once you, and in order to get there, it still can be difficult to get there because you got to get past that threshold. For example, if your community requires 75% of all owners to amend even the amendment provision, how do you do that? The first thing the board's got to be cognizant of, I think, is that this is a political process. It's not just, we're going to mail this out and see what happens. If the board really is serious about amending the governing documents, they have to keep in mind that this is a political campaign. You have to get out in the community. You have to drum up support. You have to knock on doors, talk to your neighbors, make phone calls, send out emails, all that stuff that makes a successful political campaign, and convince people, if we're trying to amend just the amendment provision, convince people that, hey, it's not fair to count people who don't participate as a no vote. So let's change this provision and make it a little more fair, a little easier for us to amend our governing documents so that we can address some of these troublesome areas in our community. One of the traps I think that a lot of boards fall into is they think, well, we want rental restrictions in our community, but it's really hard to amend the declaration. So let's not try. Let's just put the restrictions in the rules and regulations, because we can make those changes ourselves. Well, it's not a great idea. There's a couple of reasons why that's true. Number one, yeah, it's easy to amend, generally speaking, easy to amend the rules and regulations, but you can't have anything in the rules and regulations that's inconsistent with your declaration. So right off the bat, if your declaration has already established rules and regulations regarding leasing, you can't, in your rules and regs, put in something that's inconsistent. So if you think your declaration restrictions are outdated or wrong or not applicable to what you want to do in your community, you can't change those by amending your rules and regs. Even if the declaration is silent on renting, doesn't have any restrictions at all, trying to put restrictions in your rules and regulations is difficult, because in court, what that owner who's going to challenge you on those rules and regs against rentals, what that owner is going to say to the court is, look, the declaration is a contract, and it's a contract between me and the association, and it states our rights. And in that declaration, there's nothing that says I have any restrictions on my ability to rent out my property. So if the board is going to try and put in restrictions in the rules and regulations, that's necessarily inconsistent with my rights under the declaration. It's an argument that's been made, and its argument's been successful in a great many cases. So this sort of backdoor trying to amend in the rules and regs is already a problem from that standpoint. But going further, once you get into court, a judge looking at your rules and regulations does not give them the same sort of deference that he gives to your declaration. The declaration, like I said, is treated sort of like your Constitution. And judges are very hands-off about what you say in your declaration, even if the judge thinks what's in your declaration is unreasonable. You know, you can have a declaration amendment, for example, that bans all alcohol within the association. A judge may not think that's a great idea, but because it's in your declaration and because it's a contract between you and the association, the judge isn't going to second guess that. But you can bet if the board makes that rule and puts it in the rules and regulations while the declaration is silent, the judge is not going to give that the same level of deference, because the judge is going to say, well, you know, because 3 out of your 5 board members voted for this, you're going to restrict everybody's rights in that community against, you know, having adult beverages. I don't think that's going to happen. So, you know, I think boards have to, their attorneys and their managers and their interested board members have to fight that urge on the parts of some boards to use those board-made rules as sort of a backdoor amendment provision. It's not very effective, and it's subject to challenge. And if you go into court and you're challenged successfully, you may end up having to pay attorney's fees. It becomes a big mess. Better idea to do it the right way, amend that declaration, put those serious issues where they belong to be in your declaration. And I don't know who I'm turning it over to, if I'm going to Stephen or please.
Yeah, I think you're going to me, Scott. I appreciate that. I'm Stephen Thompson. I'm an attorney with the law firm of Najmy Thompson. I've been practicing in this area for about, I hate to say it, 30 years now. I started out doing land use and zoning, and have set up these communities now. You know, after I turned the associations over, many times people would call me back and say, hey, Mr. Thompson, we'd like to retain you as our association attorney. I said, that would be fine as long as you're not going to sue my developer client. So this has really evolved, and now about 80% of my work is community association work, and I really enjoy it. I love it. It's a lot of fun, and there's never a dull moment with community association work. One of the things that I have seen recently in my practice is restatements of documents, whereby communities, many times these are 30 or 40-year-old communities, condos, HOAs, that have very few amendments, but you get a new board that looks at the document and say, wait a minute, why do we have reference to the developer? Why do we have these things? And we've had one or two amendments, but we really now need to come into compliance more with 718, 720, and the changes that have happened in this area for the last 40 years. So they'll say, let's restate the documents. And that's a very important issue. And I think Scott brought up the point. The first time I sit down with a board of directors, I'll say the most important issue, to be honest with you, is taking a look at that amendment provision. Because I'm telling you right now, board, if in fact it's a high threshold, it's going to be a lot of time, money, doing the restatement of these documents with the chance that we may not get them approved. So I would echo what Scott is saying. You have to really look at that amendment provision, make sure that the board understands what that amendment provision requires. And if it's a high threshold, anything over 50% to me or a majority is a high threshold. So, I mean, if you have 2/3 or I've seen 80%, you're not going to get it done. And if you're embarking on a restatement or even an amendment process, it's not going to be successful until you address that issue. The other thing that I always tell my boards, with it, certainly with a restatement, you know, this is a process where you really need to get the community involved. You need to make sure that there's community involvement right at the beginning. You don't want to go through this process and then find out at the end, holy heck, these people, they're really pushing back on this thing. Well, the reason for that is they haven't been involved in that process. You can't expect people to all of a sudden take a look at, you know, a restated document and say, we're going to vote on it next week. You'll get a lot of pushback. So, and I think it's a good opportunity for community to kind of come together. And again, it is their declaration. It's what binds this community to basically understand what those documents say. They were developed by, you know, the developer. He had his own idea of what worked, what didn't work. The community's been there for a while. They're the ones who really need to decide what's best for our community. So you really have to embrace this opportunity and get the commitment from the community and get committees together. It takes a long time. I mean, many times these restatements may take 6, 7, 8 months. So I think it's a very healthy process, to be honest with you. Everybody's sitting down, focusing on the amendments, deciding what works, what doesn't work. Kind of is another procedural issue. Sometimes, because a restatement is a vote up or down of the entire document, there may be some controversial provisions that we might say, if it's a leasing provision or a pet provision, we may say, you know, put that out. They'll vote on it separately, so it doesn't have the tendency to pull the whole restatement down. And if it's approved, we basically reinsert it in and record it that way. There's also some other, again, before we get into, you know, the amendment itself, there needs to be a roadmap as far as the procedures. You know, as far as amendments are concerned, a restatement is a meeting required for the amendment. I mean, sometimes your documents are very specific and require a meeting. Other times, it's just a vote of the members. And so a meeting would not be required. Many times I will recommend that you're going to have a number of meetings, especially if you're talking about a restatement, just to make sure that people understand what we're talking about. Is there a joinder of the mortgage holders that's required? They've made that process a little bit easier, but again, if that's in the documents, we have to address that. The other thing that I also recommend that sometimes I don't see, I'll always recommend to the board to do a title search of all of the recorded documents. Because sometimes, you know, and we know with board members and with the members, if you polled them to see what the state of their documents, I mean, everybody would probably have different bits and pieces of the document. Some have the amendment, some don't. But if we're going to restate or amend these documents, we need to make sure that we've done a title search and we have all of those recorded amendments and all documents related to the documents. I also suggest sometimes when, you know, the board will meet and they'll say, well, we only want to amend the declaration or restate the declaration. I'll also say, let's look, you got 3 documents that control the association. You got the Articles of Incorporation, which create the nonprofit entity. You got the bylaws that go through the procedure. But we need to take a look at those documents, because sometimes, especially some of these older communities, we'll see funky provisions in the bylaws and in the articles. So when we're in this process, you want to look at all three sets of those documents. And again, especially if they're older documents. I worked with some associations that have, had substantive restrictions in the bylaws. I say, let's move those out. And sometimes you'll see even restrictions in the articles. And, Scott went through the hierarchy, and sometimes there's conflicts in those documents. And that's another reason to look to make sure that all the documents are, again, consistent. It's really, when we're talking about the restatement, it's really working with the community and making sure that we have everybody on board. And again, I think it's a very healthy experience for the community. The issue that I'm really supposed to be talking about is really MARTA, though, and I'm going to go into that. MARTA, sometimes I'll be looking at an HOA or, hired by an HOA and look at the documents. And the first thing I always look at is the date that they recorded, because the Florida legislature passed the Market Record Title Act. And I think it was the intention of the act was really very positive. Unfortunately, it's the unintended consequence of that act that we're here to talk about. But really, the intent of MARTA was really to clear old restrictions from the title. So if you had a restriction on there that was more than 30 years old, that would basically, be extinguished. And that's really important, especially, if you were doing title work and you get a binder that might be 100 pages long with all of these recorded instruments. So I think it was a very good attempt to make, certainly the transfer of property a little bit more efficient. And there are a number of, exceptions to MARTA. They don't extinguish things like easements and other possessory interests in property. However, there is not an exception for HOAs. So what has happened is when you apply MARTA to an HOA, after 30 years, that HOA, the restrictions, the declaration expires. And certainly that is a big problem. Now, generally speaking, it doesn't apply to condos, but I'm going to say that there's a caveat there. If you're part of a master association, I'm not going to go into the details, but if you live or represent a master association, you really need to talk to your local council about whether or not MARTA impacts or affects your master association. That's an issue that's certainly, there's a lot of attention right now, so you need to kind of take a look at that. But again, applying MARTA to a 720 HOA, the first thing a property manager or an owner should really do is look at the date that that document was recorded. If in fact it's not 30 years from the recording of that original document, your document is still valid. Now, many times what we do in our office, we track all of our HOAs. So when it becomes 3 years close to the 30th anniversary of the creation of that, I'll notify the property manager and the board that, hey, it may not be a bad idea for the board to preserve these documents. And MARTA does allow the preservation of HOA documents prior to the expiration of those documents. And it's a very easy process. The board can pass a resolution to basically preserve those HOA restrictions for another 30 years. Very easy, painless. However, if you go past that 30 years, your restrictions have expired. I've gotten involved in a number of cases where I've been brought in and I look at the restriction they're trying to enforce, and I say, you really can't enforce these. Your restrictions have expired and they're no longer applicable or enforceable. And when that happens, the law has provided a basis in the event that the community can reinstate the declaration and restrictions. But it requires unit owner approval, a vote. And you may find out that, you're in an HOA and a number of people say, I didn't like that HOA to begin with. I don't know why they were, I didn't have a problem with having a commercial vehicle. You may have a problem getting the owners to reinstate that after that 30 years. So it's extremely important that we preserve these documents and don't find ourselves in the situation of having to reinstate and get the unit owner approval for that. We've done a number of those. It's kind of a long process, and it takes a lot of time, and there's some money involved, but the alternative to that is not to let it happen. And some people come to me and say, well, Stephen, we've amended the document a number of occasions. That does not preserve those documents. Some people think that, oh no, well that starts the new 30 years. No, it doesn't. The amendments are still effective, but if in fact that 30 years goes by and you haven't preserved them, you're going to have to reinstate those documents. Again, it's much easier to preserve those. And every year, I think most attorneys in the community association area keep on hoping that the legislature is going to carve out an exception for HOAs. It has not happened. So it's still the law. And again, there's some dark clouds on the horizon as far as master associations. So if you find yourself that you're part of a master association, you really need to ask your counsel about that, whether or not it's applicable to your master association. But again, I would just close by saying that the amendment and the restatement process is really all about community involvement. First, understanding what the procedures and the rules are, but making sure that you get your community involved in this process. I've seen too many times where the board has worked very hard with their attorney and we've got a great document, but really hasn't shared it with the owners until the last minute. And then when you share it, all of a sudden there's a bunch of issues that come up. And again, it's very difficult to overcome that if you haven't involved and engaged the community. I think Telese is up now.
All right, thank you. I'm Telese McKay with the law firm of Icard Merrill, shareholder there and representing associations, community associations, condominiums, and homeowner associations only. Been doing that not as long as Stephen, only 20 years. So I still have a ways to catch up if I can ever do that. But so I want to build a little bit on a couple of things that both of them have stated. And one of the questions I'll start with the MARTA, because one of the questions that was posed I saw from Kathy in our chat was, what about this master association? What is going on there? And are they subject to MARTA? So the idea with MARTA is when a deed restates that it is subject to a declaration. And when you get a condominium, the reason we say it's generally not applicable to a condominium is because when a condominium is created, the deeds that come off of that to transfer title will say Unit 1 of ABC condominium recorded in da 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 da, and that is actually the legal description for your condominium. In a homeowner association, that is generally not the case. It's usually Lot 1 in ABC association as recorded under the certain plat, unless the plat then refers back to the declaration, which most of them do not. Then there's no connection between the actual declaration or restrictions and your deed. That is why, for the most part, homeowners associations have this issue, but not condominiums, because the deed to the properties don't refer back to that declaration. So if you look at a condo deed, it usually almost always does, and an HOA it does not. Master condominiums are an unusual little circumstance. First of all, a master association and a homeowner association almost will absolutely never have that deed which has any reference. A master association and a condo generally does not either. And so you can end up with MARTA applying to a master condominium association because you don't necessarily have that reference back unless there's something in the condominium plat, which again, in the master condominium plat, which takes you in the chain of title. It depends on your set of governing documents and how the condominium plats are referenced and whether or not they interreference each other. So that is why, for the most part, HOAs, not condos, but masters can be both ways. I do want to say also, I think that there has been some statutory provisions and changes which will allow some preservation from 2018 by an amendment and by a notice of preservation that the board can file, which makes the whole process a little easier. I know Steve was talking about that, and that is authorized, but your old amendments will not preserve your governing documents. And I do agree with where Steve was going with that. If you've done an amendment before in 2015, that doesn't preserve, and your amended and restated set of documents do not preserve. You got to look back at the originals if it were done before 2015. Now, all of this is important because going back to Scott's part of the presentation when he first began, you come and you want to say, hey, let's rewrite our governing documents, and you might find out we don't have any governing documents to amend. They've already expired, and that often happens. And the other part is, unless your documents are recorded, and this is pretty uniform across the board, unless they're recorded, they're not effective. So I can't tell you how many times, and I can't remember if it was Stephen or Scott, which said, we're going to require a title search a lot of times before we start these projects to see which ones are recorded, because many times I'll get governing documents from a new client and they're not recorded. And by the time we whittle it down to what's actually recorded, the last 10 amendments they've done aren't effective as of that date. We have to figure out whether or not we could retroactively record them at that point, or if it's just too late, or what to do. So we look at some of those issues. I do also want to touch base on one other thing, because I think Stephen really hit on a lot of the little tweaky things I was thinking about to bring up that Scott had also addressed. Getting your owners involved. So one of the tidbits that recommendations that I'll give an association when they're doing an amended and restated set of documents, which means amend and restate. A lot of things are restated, a lot of things are amended. When they come to me, I'll say, don't try to rewrite them yourselves. Make a list of things that are important to you. Is it parking? Is it pets? Is it leasing? Are the maintenance obligations on doors always confusing and you never know who's responsible for doors? Just make a list of those things and let me go ahead and actually draft them and figure them out. If we're unsure of whether or not the association is going to be able to get the approval, I'll say, let's hold a town hall meeting. Let me draft the governing documents, make sure the board is okay with it. Let's hold a town hall meeting before we get to the vote and discuss what we have so far. That way we can tweak some things and say we can change this and change that before we get to the vote, especially if we've got a couple of very controversial issues. Pets tend to be very controversial, or we've seen a lot of associations go into no smoking. Is that going to work? Are people going to support that? Things like that. So some getting together town hall meetings where they can meet in advance sometimes helps get people involved. And even if they don't agree with the end product or decision, having them be part of the process will give them the feeling that they have been heard and considered, and then they'll generally get on board with it a lot better. So my part of the process for today's discussion was to talk about all these little nitty-gritty things that maybe you haven't thought about, or maybe you have, or maybe we need to point out anyway, again, on what to look for amendments that either we've learned from this last 6 months or that need to be restated and reset again because they're so important. So one of the things, I would say the very first thing that I have learned on my list is we found out as attorneys that the emergency powers and the provisions that we all thought were going to be clearly applicable, when we got on statewide listservs, we all had different opinions of whether or not the association had emergency powers, because they were written in the governing written in the statutes both for condominium and homeowner associations as if there is a natural disaster. Damage to the property is really what it references in condos and HOAs. And so whether or not you have the right to suspend use rights, tell visitors they can't come in, tell people that the pool is closed, all those emergency powers arose from the statute. And most of us probably told you to go ahead and make those types of decisions and rules. But there were a good number of attorneys we found out statewide which had the opposite opinion of this isn't an emergency based on property damage, which is kind of what the statute referenced. And so can we do these things? And you may find that you're having lawsuits from owners, and we have some, I know in other states, that have said you can't do this. You acted outside of your scope. So one of the things I think you ought to really consider is many bylaws will say, or sometimes the articles will say the emergency powers, or they don't address emergency powers at all, but it'll say statutory emergency powers. I now will be drafting governing documents to be read more broadly, to say emergencies include not only situations referenced in the statute, like property damage, but also other types of scenarios, such as this particular public safety emergency, a pandemic. You may find that it's not, this was based on a state of emergency by the governor, but your particular condominium may have a problem. It's rendered unsafe, something like that. And you need to be able to declare your own state of emergency and say, we can't use the pool. I do have that with an association. They're saying, we can't use the pool, we can't use the deck, it's unsafe. And we've had a good number of owners complain, you don't have that right. And with a clear state of emergency powers that the board can determine, that would take care of that. So you may want to consider that, especially if you want the authority to close common elements, limit guests and invitees and that kind of thing. The use of virtual and remote meetings. I mean, just like we're doing here. Is this convenient? Well, heck, to some extent, I miss the personal, but I didn't have to drive anywhere to go to a meeting place. We didn't have to pay the money to reserve for the hall. You didn't have to take off work if you're a manager at this point and trying to get someplace. You can do it from your home. I see that some people are even calling in and maybe they're driving. So there are times in which having a virtual or remote meeting may be very beneficial. Probably not a problem, again, under the state of emergency to be able to hold a meeting in this way. However, once the state of emergency is completely lifted and we're done, are we still allowed to have this? I'd be inclined to say yes, but it sure would be better if I've got something in my governing documents which says we can hold virtual meetings and it will be considered that those present on this meeting, I can see we've got 49 participants, that those people are considered to be in person at the meeting so that you can do this occasionally. And it may be beneficial for those that have snowbird residents so they can actually attend even if they're not attending and feel like they're hearing and participating more. So maybe do that. This next issue came up certainly because of this pandemic in the last few months, but I always seemed like I was having a lot of issues with unrest and people wanting to post on Nextdoor and social medias and complain about the things that are happening in the association. And man, the names that came out of these groups that they had started, I had to really think, is this the association or is this a one-off group? Because the name of the association was so close and maybe the logos and the feel. And we've even had it sometimes where committee members or chairs or even board members are creating these groups which have no authority from the association at all. And I'm not saying they can't have a freedom of speech and say post what they want to post. But when it gets to be confusing with the association and you're not sure that this person, whether they're speaking on their own behalf as the chair or as a board member of the association that's unhappy with the way things are going, or if they're actually speaking on behalf of the association, that's a problem. So there is, there is discussion. You can federally register your logo and your name and so on, but I don't see why you can't also amend your governing documents to have some kind of provision which says the posting and use of association names, logos, likenesses is prohibited by anyone in the association. If it would cause confusion to the members, that it cannot be used. Be careful not to limit the rights of free speech, but certainly create grounds so that I can write a reasonable demand letter which says stop using the association's really close name. Maybe you changed one little, the apostrophe was owners with S apostrophe instead of apostrophe S. That's how close some of these are getting. So maybe put something in your governing documents to help clarification. I'm going to throw something out there that the attorneys are certainly well aware of, called the Kaufman language. But let me explain to you in layman's terms what that is. Kaufman was a case, and inherently the concept is when your governing documents are recorded and when they're prepared, if they're done in 1999, then the statute at that time is the one that applies. And if you want to incorporate some of these new provisions and these updates, we have to do this test. Is it procedural? Is it substantive? Otherwise, what we're dealing with for the purpose of most of the time understanding whether or not the new law applies to your old documents is that the answer is probably going to be no for the most part. The intention is that you still are going to be under those 1999 set of statutes. So if you want to be able to incorporate the changes in the law, and most of them you do, I realize sometimes you think that the laws you don't, but the reality is you don't want to have this, we're unsure of where we're at. You need to put something in there which says we're going to abide by the statutory provisions which apply, whether it's 718 or 720 or whatever it is, as amended from time to time. That's all it is, as amended from time to time. We call it the magical Kaufman language, but it automatically means that you can incorporate the statutory provisions moving forward, and that does create a lot of clarification. We also found out as we were going through in this last few months, the authority for rulemaking. A lot of times you think you've got the rights to make rules and regulations, and I want to touch base, by the way, the statutory regulations on rules and regulations are actually case law. Under the declaration, your restrictions are clothed with a presumption of validity. That is the standard in legal standard, clothed the presumption of validity. So regardless of whether or not they seem reasonable, it doesn't matter if they're in the declaration. But if they're in the rules and regulations, you have to prove that they're reasonable and within the scope of something you could control. And so it's a totally different threshold for that. Well, what we were finding out is things that the association wanted to adopt by rules and regulations, they couldn't necessarily do it because we found out that they had rulemaking authority over only common elements or limited common elements. And most of the time it said common elements in association property and didn't say anything about the right to adopt rules on units or lots. And so when we wanted to say certain requirements or with people coming in and out of the units to restrict access to some extent, question of whether or not that could be done if your rulemaking authority didn't extend to the use of units as well. Look at that language. A lot of times, even newer documents will say the board has the right to make rules and regulations regarding common elements. That's great, but what about the units? So make sure that you are looking at that to be able to update that. Another thing that we found to be very important is the authority to require registration or notification for guests and invitees as they were coming and going, which would be contractors, family members. It seems very intrusive at times to be able to know who's coming and going from the property. But if you have an emergency, and think of it more in a hurricane, although we dealt with it a lot on this particular pandemic, I can't tell you whether everyone got out of the building or not if I don't know who's in the building. So having some type of registration or update that happens is helpful. More so, far more so in a condominium, especially in a high rise, but it can be in other associations as well. So consider that ability or authority to do that. Let's see. Oh, enlarging the authority to conduct business within the unit or the lot. Think of how many governing documents, just about every set of governing documents which says no business can be conducted in your unit or lot. Well, probably that's what you want, but not necessarily, as we've all been working from home for the last 3-4 months, not necessarily those businesses like I did. I set up my desk and I'm working and you wouldn't know. My phones are forwarded. I've got 2 screens and monitors, meeting with clients via Zoom, and shouldn't matter that I'm actually working and having business in my home. So check your governing documents. Some of them are written more broadly where they would say, okay, it's business except if, and we can't tell from the outside that there is business, there's not coming and going, there's not huge deliveries happening. But if you just got a no business provision, it may be too restrictive and you need to update that. Homeowner associations need to probably update your homeowner association election process. If you're still requiring nominations from the floor, consider whether or not you need that. I know most associations don't even like that, and they tend to use nominating committees or People are required to self-submit their own nominations in advance, things like that. If you're going to be looking at more and more remote meetings or streamlining, and because so many associations are streamlining their processes right now with electronic means, nominations from the floor and requirement that that has to happen, you may not want that. Or some associations, homeowner associations in particular, don't hardly have an election process in their governing documents. It says the elections are supposed to happen once a year at an annual meeting, and there really isn't any process, or it says by ballots, but doesn't give much. So figure out whatever process works for you and put it with more detail in your governing documents. Many of you may have suspended your annual meeting and maybe still haven't had it. So thinking about how this would be easier the next time, if we had ballots that were sent out, if we could do a Zoom meeting, it might be much more helpful on that. Let's see. Again, amending the bylaws to authorize the use of electronic notices for meetings. That's both for condo and homeowner association. You know, you can send out your notices via email and use electronic, but it has to be in your bylaws to be able to do that. And what I'm seeing is a lot of documents in the bylaws will say notice must be mailed or delivered, or just mailed 14 days in advance. And if you technically are looking at it, it says mailed. And we've had election disputes or amendment disputes where it wasn't mailed because they were using email, or they delivered it because they were going door to door and they didn't technically meet the notice requirements. So it might be time to update that language as well. And then there's always things, and a couple more things that I had just on the list of things to Highpoint. Maintenance obligations, and especially in a condominium, we've seen this has nothing really to do with the pandemic or the last 6 months, but just in general, because of age of buildings, the water heaters are going and they're flooding condos, or there's low flow toilet valves that have not been installed and they're overflowing or using more water. And if water is a common expense, it can be very expensive. So if you're amending your documents anyway, maybe put something in there which says we're going to require proof that you've changed these out every 10 years. Or there's a presumption then, if there's a flood, that you have failed and that you are negligent in doing so. And it helps provide a rise, and especially in the condominium setting, when insurance is triggered, if there's negligence that can be shown on the owner or unit owner's part, then the association may not be responsible for paying that deductible or going in and having to do that work. So if you're wanting to make those kinds of amendments and help protect yourself, you definitely have to put that in the declaration. Make sure that that is okay by enough of your owners to support that. And then finally, what I'm finding a lot of in older documents, and it doesn't have to be very old, are the finding suspension processes are backwards. Because the statute changed not all that long ago, and it used to be that the committee would hold a meeting first to impose the fine, and then the board. Now it's the opposite. The board is imposing the fine, and the committee is either confirming or rejecting. And so the governing documents are saying one thing, the statute's saying something else, and without this Kaufman language, the associations are going, which is the correct process? You go to collect, and you're maybe you're able to collect, or maybe it's determined that the fine isn't valid and you're not sure. There's also how much on the fine. Homeowners associations can go above that statutory fining ceiling of $1,000. Maybe you want that. Maybe that's, but you got to have it in your governing documents and make sure that that's all part in there and clearly established in your governing documents. So those are all little pieces of, hey, things to think about when we're doing amending and restating documents, or amending little pieces of it, but certainly things that we have learned in the last 6 months that are becoming very important. So I'm going to open that up to Scott and Steve and see if they have also had some other little provisions and tidbits that would be useful.
Let me just pick up on that while you're talking about fines, because I've come across this very recently on a couple different situations, but the authority to lien for fines is generally absent in a lot of documents that I've looked at. And it's not, the statute is, you know, as per usual from the Florida legislature, not a model of clarity. So if you have fines that are, you know, for example, in an HOA that are $1,000 or greater, and you want the authority to lien for those fines, generally speaking, you have to put that authority directly into your declaration. And it's generally not present in most documents that I review.
No. And it's also not clear on exactly what the process is. I've done a couple of liens for fines, but you're somewhat flying blind on how that's supposed to be. And so having a little bit more on how that works, it would be helpful. A little bit more policy, you know, procedure.
I'd agree, especially because I don't know what your experience is, Telese, but my experience is that judges are not huge fans of liens for fines.
They're totally punitive.
Yeah.
They're completely punitive. I will say this about fines since we're on it. Because they're so punitive, if there's the underlying issue that you want fixed, then go after the underlying issue. If you want someone to repaint their house because, you know, Pepto-Bismol pink is not an acceptable color, then fining them is like punitive. But at the same time, what you really want them is to repaint the house. So push that issue instead of just the fine. Fine is, to me, a slap on the hand for not following process, but doesn't get you to the end point of where you want to be. So, yeah. Steve, you look like you're just dying to say something.
I'm just looking at some of the comments about Scott. But anyway, a couple of the other issues that I always look at is the approval process. Certainly, you know, many condominiums have that in their documents, but HOAs are also moving to that, and sometimes they're actually have an approval process without any basis in their documents. So that's one thing that we look at. The other thing, I was just looking at a condo approval process that had the right of first refusal. So if in fact they denied an applicant, they basically had to exercise the right of first refusal. If they failed to do that, then that owner and the prospective purchaser could actually move forward with the purchase. So again, I always like to look at that approval process. Certainly when I first started many years ago, most HOAs didn't have an approval process. It's really been part of the condo, but now that has really shifted, and about 90% of the associations I represent now have some kind of an approval application process for both owners and tenants. And I think that's an important element of community associations and making sure, and part of it is really, I think what Telese was suggesting, we really need to know who's there. You know, who is, you know, you get some new people in there, tenants, and if they, that's a, you know, an approval, at least an application, you know who's there, who their car is. So that's an important part of it. But also I think it serves another important function. I mean, as far as, you know, if you're going to deny somebody for, you know, the reasons, you have that process. Some of these HOAs that I've been representing, they're denying people, and I go back and say, where's the basis for that? So that can be a problem too. So when you're amending your documents, that's certainly an area that I look at. The other area that I think Telese brought up is a good one, is that maintenance obligation. That is always a source, certainly in condominiums, of issues in regard to who is responsible for certain things. And I think that's why it's so important to get the community involved in this process, to make sure that there's a clear understanding, you know, who is responsible. And the other issue that I run into, say, for example, if there's a pipe in the bathroom and the association has got to go through and, you know, cut a hole in the floor, you know, does the association want to be responsible for the damage to the unit? Or is that going to be a unit obligation? So again, unless it's in the documents, you know, it creates a problem. But I think that maintenance provision or the responsibility is an important consideration when you're, certainly when you're restating your documents, certainly as far as condos are concerned.
You know, building on that too, if your documents don't give the association the authority to go in and make some of those maintenance obligations, if an owner fails to do so, that can be really detrimental, because you may be left with having to pursue a lawsuit to be able to do that. We're just talking about that in an association I have in which the AC is not on, the electricity is not on. So associations trying to force the owner to go do it, it's just much easier to be able to go and have the association put the electric in its name and assess the owner for that because of mold issues in a condominium.
Right.
You don't want to have those kinds of concerns, and I don't really want to spend a lot of money. The lawsuit's winnable. There's no question. An arbitration in a condominium, you know, we can win that, but I really want the air just turned on so that we don't have mold concerns, things like that. So those kinds of maintenance provisions at the end of, okay, you're going to maintain this, we're going to maintain that, but the what if it doesn't happen kind of provision needs to follow those. And it may have to give a little bit more self-help, because I'm telling you, if you want to go in and do it yourself, otherwise you think, hey, this is a real big safety issue. I'm not sure the association has the right to go in and turn on power without something specifically in the governing documents, which says that you do, especially if you intend to collect that money from the power and light bill afterwards. So,
and then you need to put it in there. You collect that money as an assessment and put on the ledger of that owner. And that really should be in the documents too.
Right, right. There's all those little tidbits that you're really starting to learn are so critical, especially when you're dealing with insurance issues. And who's going to ultimately be responsible if something happens. Well, the association ends up having to foot the bill for so much in a condominium as part of the original building. So maybe help prevent some of that in advance. It would be less expensive. So, see, one of the questions that we have is, how do you convince people that vetting is even a good thing for leases or sales? And I'm finding that most associations, it's not trying to talk them into, let's put in a vetting process, although that can happen. But, you know, the easiest example of why we should be vetting is not only for the emergency purpose, but who do you want living next to you? And you don't have a lot of authority to choose your neighbors from a legal perspective. But if there's a convicted, you know, sex offender or felon that's just getting out, there may be.
Or a lawyer.
No, you can put in, I haven't seen the declaration yet, which says no lawyer, but I've been drafting them, so maybe that's why. You know, if it's right in your declaration, you tend to be litigious. So, but most of the people want the ability to even familiarize. You're probably not denying people as much as you are trying to get them to familiarize. Be familiar with the community and make sure that they understand what the feeling and constituency is.
And not only that, but also making sure that they understand the documents and the declaration and what those restrictions are when they move in, what's expected and required of them. I mean, and that, you know, a lot of associations have that process. And I'm somewhat an advocate of having that interview, primarily the dissemination of information and making sure that they have the right documents. I mean, you know, they're supposed to get that closing, you know, but many times they don't. And so it's important certainly to go over those restrictions and, you know, what they can do and what they can't do to avoid potential problems down the road.
Yeah.
I think that's a good point, especially for folks who are coming from out of state, who might not have lived in an HOA or condo before. I think, you know, setting their expectations that they're not the lord of the castle, that they do have to follow certain rules and regulations of the condominium or the HOA. That's a good conversation to have early.
And the other thing that I find is that, you know, people move in from up north and they say, well, everything's taken care of. I don't have to worry about insurance or anything like that. And then we say, wait a minute, you have to have insurance for your contents. And in the event that that water heater, you know, you need to have insurance. I mean, some associations want to put that as an obligation in their document. When we're redoing the documents, I always say, no, you don't want to do that, because then all of a sudden you assume an obligation or responsibility that many times you can't enforce. And then when one of those things give out and that downstairs unit owner, when we tell them, oh, you got to go up against the guy upstairs, they're going to say, wait a minute, it was in the documents. You should have been inspecting that. So a lot of communities, especially older communities, where, you know, the water heaters are now 15 years old, they're saying, why can't we go in there? Why can't we change our documents? I said, because you're assuming some liability. You know, I think what you do is you put a letter out and you suggest, and you do that, but you don't assume. And some associations even want to send their maintenance people in there to inspect these darn things. So
One of
I
the
see it.
questions that
Go
just
ahead.
came up, I'm sorry, was
Go ahead.
can we use background checks for vetting? And yes, absolutely, you can. Put that in your governing documents. Definitely have it in your declaration as part of your leasing or sales. But understand that you're looking for something that's extremely egregious. We're not going to be denying or recommending that you deny. Even for things that would be criminal, petty theft or anything that's too old, I'm not inclined to say no, deny that application. But there's only been a few, and I have recommended a denial, but they're either very, very egregious, very recent. I think the sex offender is the one I feel completely comfortable with, and I have had one where it's a sex offender that was getting out next week. And that I felt comfortable to say, I think that we're okay to say no to this. But for the most part, you're looking for that kind of huge event. I don't know how you two approach that, but for me, you end up discrimination claims too often otherwise. What do you think?
There were some new HUD guidelines put out maybe it was last year on that very question. And I think that laid it out, and exactly as you're saying, Telese, you really have to have an individualized consideration of the facts and circumstances of the particular offenses. Like you say, one of the big things is how old are they? Well, if it's 20 years old, not that urgent. If it was last year, if the guy's just getting out, obviously a little more urgent. What's the severity? Was it a violent crime? Was it a sexual crime? Or was it just a property crime or, a drug offense or that sort of thing? And that really takes, you really have to look at those case by case. You really can't make any blanket rules, I don't think, on those sorts of things.
No, I will say one of the questions that comes up a lot, what about the financial? What about the checks for financial feasibility? Yes, credit checks. I've got an opinion. Do you have an opinion on that, Scott or Steve? Mine tends to be opposite of what others think. But I don't like it. I think that credit check alone, especially for when it comes for tenants, is a very bad road to go down, because the tenants generally are not financially responsible for the assessments, and the associations, even with a sale, has the right to lien and foreclose on a unit. So there's other viable opportunities for the association to collect. And you just don't know the circumstances, whether they've had a bankruptcy, a divorce, very bad health issue that they were trying to make ends meet. So I don't personally like credit checks at all as the basis. I'm not saying not seen in totality, but as a basis, I would say that's not sufficient for me.
I have the same opinion. I just think when the tenant doesn't have a direct obligation to the association, it's really none of the association's business at that point. And I think it's something that, certain boards have used in the past as a means to keep people out of the community, as an excuse to keep some people out of the community that they wouldn't otherwise want there. I just think it leads down a lot of bad roads. I advise clients, if you're going to run a credit check, maybe it's something you can consider, but I certainly would never advise a client to reject somebody solely based on the fact they've got a bad credit score.
I'm going to
I don't have a problem with denying based upon the credit score. I mean, a condominium is in a unique situation. There's an interdependence upon somebody's ability to pay assessments, and especially coming out from, the problems that we've had in the past where we had high levels of people not paying assessments. I think it's a very useful tool to avoid people coming in and not being able to afford to pay their assessment. So I'm an advocate of the use of the credit check and using that as a basis for approval or denial.
Well, I think we have to distinguish between ownership and tenancy. If it's just a tenant, I'm not a big fan of the credit check, because the tenant doesn't have any financial responsibility to the association.
The only thing I would say about that is, though, that if your tenant has bad credit and is not going to pay, the rent, there's the potential problem that, the owner may not be able to pay. He's depending upon the tenant to pay the lease and to use that for the assessment. So that could be a problem.
It can be. But I'd put the onus back on the owner personally. But
Oh,
that's,
I agree, but
Yeah.
I think it's an indicator.
One of the questions, and then I'll probably turn this back to the amendment part of the process. Can you put in an amendment for a background check and still not have a right of approval? I suppose so, but then why bother requiring any type of check? If you're not going to have approval, then I usually say ask for information, registration, so you know who's there. Again, in the event of a fire or something happens, you need some type of emergency contact, especially in a community where there may be some old ones. It doesn't have to be older individuals, but especially with older individuals and there's health concerns and you need maybe a family member or someone else to be able to contact if there is something that comes up. So I think you want to have that information. Yeah.
What do you guys feel like? I've had this, and I haven't had these questions in a long time, but I had two just recently on occupancy regulations. Like when the parents are out of town, can their kids use the condo, that sort of thing. Have you seen a lot of those, and are you big fans of them?
I draft a lot of them, trying to close up those loopholes. And, you know, it just depends. I've done them in, I was just thinking, I did it in an amended and restated set of documents last year. And man, did I just get harassed by the owners at our town hall meeting of how in the world would, you know. And then there's other associations that say, thank goodness that you thought of the loopholes. Whereas no matter how long somebody stays there, if they're there for more than 14 consecutive days without the owner present, I don't care if they have a lease or not, they're considered a tenant and they've got to go through the process. It just honestly depends on the threshold of how that community wants to be governed. And a lot of times I'll put things in there in the amended and restated documents. The leasing provision is kind of long and beefy, and then to show them what's available. And then they can have me delete it out and say, we don't need that much regulation. We don't want to do this. We don't need to do that. But I tend to put otherwise a lot of definition in on that kind of thing, just to close up loopholes when you want it, and they can decide if they don't want it.
I agree with Telese, and we're seeing a lot more of that, especially with the, you know, the increase on the islands with people leasing, and you know, they have limitations on the number of times or the duration. All of a sudden, you see all these people coming in. Oh no, we're guests. Oh no, I'm, you know, the great uncle. You know, and I think it's almost like you know, the fair housing. I mean, as far as the reasonable accommodation, you know, as far as, oh no, we're guests, or you know, when really they're short-term tenants. And I think
everybody's got a cousin in Miami, isn't that what Jimmy Buffett says? I swear that's what we get sometimes.
So we're trying to tighten that up, Scott, primarily.
Yeah, I've had a recent spate of them, but I hadn't had them for a long time. I was just kind of wondering if I was alone.
No, and especially with the Airbnbs and the VRBOs, we're seeing more and more. Okay, how can we prevent that? Because somebody will say that they're here and they're just visiting or just staying. And at some point we have to put in some kind of other threshold other than a regular, hey, it's a lease for money and we put it, you know, here's our 3-page lease or whatever. Having to figure out if they really are a tenant otherwise, or somehow they're, you know, the use alone based on occupancy. So I think I'll tell you this, if nothing else, I want to have a governing document which says the board of directors has the authority to adopt definitions on occupants, on tenants, and so on. So even if it's not in the declaration, I have a fighting chance later where they don't think they want it now, but they might want it later. And maybe if I've got something in there which says they can adopt it by rule and regulation, it's got to be clothed with the presumption of validity by the time we do it in the rules, but maybe we can help close up that gap. So I'd see it that way. I do want to circle back around on one issue and then see if there's any further questions on this. But I know when you get started, one of the first things you're looking at is the amendment process and the approval process. I don't want associations to be dissuaded for doing an amended and restated set of documents, or from doing even a simple amendment, because sometimes the mortgagee approval is required. Oh, yeah. I will tell you this, and I think Stephen touched on it, that he says he looks for it, but I've done several of them and they're daunting in from what it looks like, but the actual process is very easy. The daunting part is figuring out if each unit or each home has mortgages or liens on them. And that is the harder part. They can be done by title searches on each one. And unfortunately for that, it's just a matter of expense. But the actual process itself is actually pretty straightforward, and it's just a matter of keeping the list. You get a list by the title search of who the mortgagees are, let's say for a condominium. You send a letter out, and it's a form letter, really. It's prepared, and it says, we think your property is encumbered by, and then we just insert like a little label which says, you know, ABC Mortgage Company. Do you agree? Do you have another address? And so on. Give you 30 days to respond. And then it's another form letter that's sent to ABC Mortgage. We, you know, have to get your approval. But approval is deemed if they don't respond within 60 days. When's the last time you've ever had a bank respond to you for anything within 60 days? So the chances of getting a response at all, you know, I think honestly, and as many as I've done, and it's not been a ton of time because there's not a huge number of documents, but 5 mortgagees have responded over the number of associations total. And each one I've been able to call up and say, let me explain what this is. By the way, it's against public policy. We're not even allowed to put these kinds of provisions in the governing documents now, which require your approval. And I'm not changing anything fundamental. So it's just a process. It's not as daunting as you think. Don't skip it.
You can't skip it, because the first time you try to enforce those, somebody's going to argue these documents are defective because you failed to get the joinder of the mortgage holders. It could potentially throw out the whole restated document or an amendment. I've had that attack before.
Yes. And on top of that, we have just seen a case that came out not all that long ago on the same concept of MARTA. Well, I'm just going to keep enforcing these governing documents because right? It's too much work to go get them restated. And so we're going to do this collection anyway, or we're going to, you know, enforce these restrictions. And hey, that doesn't work. And I'm telling you now, attorneys are going to be a little gun shy on trying to make that work for you. So.
Oh, you could not make that work. Try to enforce something that's been, I don't know of any attorneys who've tried to do that.
Not in this group. Not in this group. So those.
Thank goodness, Scott.
Maybe a little bit.
Only if the money's really, really good. No, it's just, there's so much liability and so much. So let us help you through that process, and do it correctly, and don't shortcut those. So you want to we've got about 15 minutes left if we have further questions. Otherwise, we don't need to continue if there's not questions, and we've answered so many questions as we've gone. Guys, do you see questions that we need to answer?
Yeah, actually there's one asking about a specific community. How can the board prevent the use of owners setting up a Facebook site or other, I guess, social media sites to do with the neighborhood? What should boards have in their documents to prevent that sort of thing from happening?
I think that was the issue that I was talking about. One of the, I think, the third point that I had, which is to actually put something in your governing document. I mean, you can register and trademark and federally register, and but why not just put something in your governing documents, which just says you can't use the associations, anything which gets to be too close to the association's name, logos, likeness, and so on. It's not as ironclad as having a registration, but it at least makes me feel as I'm doing a demand letter, then if we've got to go to pre-suit mediation or arbitration or something. So they say there's a provision in here which says, we believe in our opinion that your name that you've got for your group, your Facebook, your Nextdoor, your whatever, is close enough to the real thing, our association name, that it's causing confusion. And sometimes they really do. I've had cases where even I was like, that is so close, I wouldn't be able to tell, because things were being posted by those individuals which otherwise appear to have authority for the association. So put something in there which would at least give you some teeth to try to pursue.
And there was another question that came in while you were answering that, Telese. When changing the amendment process, what are your thoughts on making the simple majority of those that vote versus 66%? I've seen a couple other questions on this point, you know, seeking the magic number for approval of amendments. And my personal opinion is there's no magic number. It's really what your association is comfortable with. But one of the concerns a recent client came to me with, and I think this is a good point and something to think about. We typically, as lawyers, we're looking to make it a little easier to amend. But if you make it a percentage of just those who are present and voting, you might not want to make it too low. Because if it's only 30% for a quorum and you only need a simple majority, then you might have a situation where you have, just over 15% of your community dictating what the amendments are for your declaration. That's not a great situation for the association to be in. I don't know that there's a simple answer for that either. It really depends, I think, on the association's comfort level, the type of community they're in, and what they're seeking to do. But I think there's a danger in making it too easy to amend. Probably a better problem to have than making it impossible to amend. But it's just something to have a conversation with the board while you're in this process, I think.
And I always, at least at a minimum, I'll say it needs to be 51% of the owners. Because
Right.
I think I agree with you, Scott, when you start looking at the percentage of the quorum, all of a sudden that can be a very low number. But again, if you've got a community that nobody really cares about, it's still going to be tough to get 51% of the unit owners. But I do have some concerns going to, a majority of the quorum, when your quorum is 30%, that's a very few number of people. But I always like to at least suggest to my associations, let's at least do 51% of the owners. And nobody can really argue with, well, that's a majority of the community.
Yeah, I agree.
Because when you go higher than that, they say, well, that requires more people. I said, that really doesn't require more people. What that really means is you can have a very small minority of people who control by not voting.
Yeah.
And you can never get anything done. At least a majority. And maybe it's a couple of steps. We might start with a majority. And if that doesn't work on something else. But at a minimum, I say at least 51% of the owners.
There's a couple more questions. Yeah, I've seen a couple actually come. Do we need CDD approval? Do we need master approval? Do we need to integrate for when we're doing amendments? It just depends on what your governing documents are and how far intertwined they go into these. I mean, I would say most of the time, no, an HOA doesn't need CDD approval. They should have separate requirements, especially with a CDD. It's not the same kind of entity as a homeowner association or a condominium association. But it also leads into the question then of how much do all these kinds of projects cost. And I'll say it really varies when I look at them on how many amendments they have. The one association I had that had the most amendments, 46 amendments. Yeah, and so you're looking at that going, in order to make sure I've got all of these and figure out which ones trump and get the last one, and then and to get them incorporated, plus then just my regular updates. It was just a lot of work, because otherwise I've got them all spread out on my desk, each amendment in the different colors, and I figure out, and then I put my own personal spin on it. But when I have 46 of them, you better believe that it's going to be a totally different process. And then I think I took forever to actually do that set of documents, because I was just like, oh, I can't do that today. No, I can't do this today. Not today, So it takes a lot. But if you've got different layers, sometimes you do have to look at the different layers. That is going to take more time. That is going to take more effort. Most of the price points or projects won't include getting mortgagee approval or doing some of these other spin-off issues that you might have as a flat fee, which you might otherwise get in a set of governing documents. So I don't know if you want to talk more about costs with more specificity, but I think it ends up just depending on so much of it from my personal opinion. I don't know if you either want to join in on that or.
Okay. It does. I don't think you could come up with a flat fee to cover every situation. I think it's impossible. There's so many different situations you're faced with, whether you're a condo or HOA, whether you're a master association or sub association,
Right.
it's tough to say in a vacuum.
we've done flat fees. The problem is that, you know, we kind of get a good idea, well, how much it's going to cost to prepare the documents. The issue that really kind of skews the number is the number of meetings. If in fact the board says, you know, we're having problems with the owners, you're going to have to come down here. And so that's really what I think adds to the cost, because I think we can probably give a pretty good idea of what a restated document's going to be. The issue, the unknown is really, if you've got to come down there for 5 meetings or have 3 meetings with the board, then that's what really begins to, you know, change that proposal or that flat fee.
Absolutely. If you give a flat fee, and we normally try to do that, it's just for the drafting.
Right.
It doesn't include the extras because we just don't know. By the time even changes, I say a one-time change, it includes a one-time set of changes, because otherwise you could end up with 15 different meetings and changes and back and forth. And at some point, it's very, very difficult to keep all that in mind.
And especially if you're going to be doing the title work for mortgage holders and then putting those packages together, that adds more money to it too, that you really don't know at the beginning of the process.
I think it has to be an ongoing conversation,
right,
of how the process is going and where we can go. You obviously don't want to get into the project and then not have the support of the owner. So it's worth having and doing these town halls or communicating or making changes, but it can get to be different. There were a couple of good questions I wanted to touch base on. If there's a lot of amendments, do you do them in priority order, one big change? I would do one amended and restated, do one thing, get it all in there that you want. It's just a huge project, but it ultimately, it will be less expensive and less time consuming for the most part to do one big amended and restated, and then leave out, like Steve had said, or maybe as Scott had said, if pets is one thing your community is divided on, leave it exactly as worded. Do not change a single word of that, and leave it so that you've got a full set of documents that everyone can basically get on board with, and then go back and figure out if you want amendment number 1 to deal with pets, and if you can get it, and if it doesn't pass, you haven't done this huge project. And the other question that was on, what about mortgagees? Do you have to keep going back and get them? No, you get them once. And what I do is I will, kind of what Scott was talking about, go back and change your amendment process first. Go first to get the amendment process to lower the requirement if it's needed for the owners, and whichever one it ends up being, get the mortgagees out of there. And so if you've got that part out, you've got to do it once. You got to go get it once, because that's what's required if it's already in there. But for the most part, keep in mind, mortgagee approval is only needed on things that you're not going to be changing, that no attorney will touch. It's the changing of the percentage interest, or the way you share in your common expenses, things that are framework for a community, and you're not changing those anyway. And under the laws nowadays, in the last 20 years, you can't require mortgagee approval except for those items. So we've got a few more minutes. I think we've answered most of the questions. Do you have any further items, or Scott and Stephen, to address?
I do not.
All right. Karen's back.
I'm back. And I want to say thank you so much, Stephen, Scott, and Telese, for a wonderful session. It was great. And from the comments that I think we're seeing, everybody enjoyed it and got a lot out of it. Thank you, everyone, for attending. I greatly appreciate it. We do have a couple of another webinar next week. So if you want to go to our website and look at that and register, that would be great. And I thank you all. Stay safe.
Thanks,
Thank you.
Thank you, everyone.
Thank you.